Assalamualaikum warahmatullahi wabarakatuh. This is a chapter of company law. Basically, a company ni terdiri daripada dua jenis yang biasa kita tahu, which is sendirian berhad dan juga berhad. Public limited company, limited by shares. Okay, so what is the meaning of sendirian berhad? Sendirian berhad means a company that is different from a partnership, lain daripada perkongsian. And what is the meaning of sendirian berhad yang berlainan daripada berhad? Sendirian berhad is a company that doesn't have shares, dia tak ada saham, whereas a berhad company has shares. That is the first point that you have to know. Why we do have shares? Why is it that we have shares, saham? Is when the company gets so big, they can actually apply to have a status of berhad. Meaning, they have to get a corporate lawyer to help them to do all the necessary legal paperwork in order for that company to qualify to be a berhad company. When a sendirian berhad becomes a berhad company, that means the company can keluarkan saham, shares in the form of paper money. These shares are actually just papers, but it can be sold, boleh dijual, or another word, floated, F-L-O-A-T-E-D, floated on the Bursa Malaysia ataupun the Malaysian Stock Exchange ataupun Bursa Malaysia, to ask people to buy the shares. When people buy the shares, for example 1,000 lot untuk harga RM1,000, maka the company immediately dapat RM1,000, RM1,000 as capital. So they can use the money to develop the company for their present investment or future investment. This is how a berhad company can get capital from outsiders, from the public. They can also sell their shares to the employees of the company. A sendirian berhad do not have the privilege, dia tak ada kehebatan itu. They do not have the permission to sell shares on the stock exchange. But still, a sendirian berhad and also a berhad company, a public company and also public company limited by shares. Public company limited by shares adalah berhad. Sendirian berhad is a public company. Still, both of them are very special. Why are they very special? They are very special because they share one common characteristic. That characteristic is the company of sendirian berhad and also berhad, they have, the company itself have the life of their own compared to a partnership. Recording number 2, company law. We have, if you look at the PowerPoint of company law, there are many acts, banyak akta. But what I want you to know is Companies Act 1965 dan yang terbaru yang telah ambil alih Companies Act 1965 is Companies Act Companies Act 2016, Companies Act 2016 dan juga Companies Act 1965. Itu you kena ingat, ada dua. Tetapi yang terbaru tu yang lagi banyak dia tokok tambah is Companies Act 2016. Jadi for company lawyers, Sebab yang expert pasal Companies Act ni kita panggil corporate lawyers lah, ataupun company lawyers. They will refer to Companies Act 2016 dulu. Bila tak ada apa-apa provision dalam 2016, baru dia tengok pula provision lain yang belum dimansuhkan, that is present in Companies Act 1965. Okay, so now kalau you pergi lagi in the PowerPoint, tadi in the recording number 1, Madam say a public company, Senam Berhad, and also public company limited by shares, Berhad, they have one common characteristic, which is the company has a life of its own. Dalam bahasa lain, you have to remember, the company has a separate legal personality. Ataupun ayat lain, it has a corporate personality, dalam bracket separate legal personality. That means separate legal personality ni sangat berlainan, different from partnership ataupun kedai yang seorang diri je duduk situ, sole proprietorship. Di mana separate legal personality ni, it means the company has a personality that is separate from the founding members. Maknanya dia ada personality, dia ada nyawa sendiri, syarikat Senam Berhad dan juga Berhad. Di mana the people yang ada saham terbesar, directors, ataupun kita panggil board of directors, BOARD, board of directors itu you cannot see from the outside. So you see kalau orang nak saman, if people want to sue the company, they cannot sue. Dia tak boleh saman, okay? They cannot sue SUE. They cannot sue the Ali bin Mamat katakan, ataupun Mamat bin Abu. Mereka ni semua adalah board of directors kerana menipu katakan, for cheating. They cannot do that, sayang. They can only sue, let's say Madam Malina tak puas hati dengan syarikat Nestle. Madam Malina versus Nestle Berhad. Understand? Madam Malina tak boleh saman macam ni tak. Madam Malina versus Ali bin Mamat, defender number 1, defender number 2 Mamat bin Abu. Tak boleh. That means selamatlah. So the benefit of making a public company is, bila kita buat salah pun sebagai board of directors ataupun pemegang saham terbesar ataupun founder, FOUND, the public cannot sue us because we are now behind the veil, VEIL. Kita sekarang di belakang tabir. Like Mak Saleh kan, bila dia kahwin, they wear a wedding veil, VEIL, macam hijab warna putih. So directors tu is behind the wedding veil, behind the corporate veil. Orang tak nampak lagi, orang nampak hanya di depan, which is the company. So the board of directors, katakan ada 10 orang, the public will not know, okay, except when the public check the statement of accounts or of the company at the end of the year. Kalau tidak, dia tak tahu. Unless dia pergi tanya company itu sendiri or baca brochure company itu. Okay? So that is the meaning of separate legal personality. So the separate legal personality ni, it can be sued, maknanya company tu boleh disaman, can be sued in its own name. Kita saman nama company tu sendiri, ataupun company tu may sue, boleh juga menyaman orang lain, may sue other people or other companies using its own name. It has perpetual succession. perpetual, perpetual, PowerPoint number 9. Perpetual maknanya it goes on and on and on, although the board of directors or shareholder tu meninggal dunia, pass away, the company will not die with the board of directors. Okay. And then the liability of the members may also be limited to the amount of their shares. Kalaulah syarikat tu bankrupt, katakan rugi 20 juta, maka 20 juta tu you kena ambil berapa persentage sahaja Nik Malini pegang saham syarikat. Katakan saham syarikat ada 20 juta juga, 20 juta lot, maka Nik Malini pegang hanya 1,000 kan saham. Harga 1,000, maka Nik Malini pun rugi hanya RM1,000. Tapi dia orang tak boleh ambil lebih daripada harga 1,000 tu daripada madam. Recording number 3, company law. So basically to wrap it up apa yang madam cakap tadi, a company has its own separate legal personality, meaning that the company is itself separate from the members of the company. Members sini maknanya pemegang-pemegang saham. That means the company can sue another company menggunakan nama syarikat tu sendiri. Okay? Nestle Sendirian Berhad versus Renung Sendirian Berhad katakan. Ataupun Nestle Sendirian Berhad versus Madam Malina. Okay? Or the company can be sued in its own name. Maknanya Madam Malina versus Nestle Sendirian Berhad, ataupun Ali bin Mamat versus Nestle Sendirian Berhad, ataupun Ali bin Mamat versus Nestle Berhad, because both Sendirian Berhad and Berhad are essentially the same thing. They are public companies. The only difference is Berhad have the right to issue, keluarkan saham, so that it can always enlarge, besarkan syarikatnya sendiri dengan meminta capital ataupun wang, money from the public by selling paper money, by selling shares. So conclusionnya, a company is an entity, entity. Entity ni maknanya sejenis benda lah, benda that is separate from its members, and the company tu wait one moment. One moment. The company is separate from its members, and then we also have to remember that the liability for the members, pemegang saham tu, of the company is limited by the amount of their shares. Hanya terhad saja. Jadi kalau syarikat tu rugi 30 juta pun, kalau kita hanya pegang saham sedikit, kita rugi sedikit. Itu maknanya. But if we is part of the rakan kongsi, kalau kita ni rakan kongsi perniagaan partnership, kalau partnership rugi, kalau kita ada saham sebanyak itu, maka kita akan rugi lebih daripada harga saham kita, sebab all of us akan rugi besar. So liability of members of a partnership is unlimited. Liability of members for company is limited by the amount of the shares. And then the company can also mempunyai own assets in its own name, whereas a partnership cannot own assets in its own name. Partnership punya asset adalah dalam nama pemegang dalam nama rakan kongsi itu sendiri. And a partnership, dia akan digulungkan, will be terminated when the rakan kongsi meninggal dunia. But whereas a company, if the board of directors ataupun one of them is dead, meninggal dunia, the company we have perpetuity, Ituity. Maknanya company will go on and on. It won't die because of that. Okay, company law recording number 4. Madam wants to speak again about the corporate veil, VEIL, ataupun separate legal personality of the company. As we know, because when we incorporate ataupun kita membina satu syarikat, incorporate ataupun incorporation of a company, from that point onwards, when we go and register with who do we register? We register with Malaysian Companies Commission. Remember that. We register a company under Malaysian Companies Commission, which is under the Malaysian Companies Act 2016. Whereas di mana partnership pula kita register di mana? Partnership perkongsian will register with Malaysian Companies Commission, sama juga, tetapi Malaysian Companies Commission ini is under the akta yang berlainan. Partnership will register with Malaysian Companies Commission under the Registration of Business Act 1956. Yang company itu registered under Malaysian Companies Commission under Malaysian Companies Act 2016. Another thing that we should know, which is also important, is that the company, because it have a life of its own, okay, ibarat dia bernyawa dengan dirinya sendiri, ibarat kita tak nampak siapa pengasas mereka, kan? Because pengasas is behind the veil, macam hijab lah ataupun tudung mak saleh yang kahwin tu, the veil of the bride, BRIDE. So how do we manage the company? The company has its own Al-Quran ataupun the company has its own Bible, okay? So how we manage tadbir urus syarikat itu? Tadbir urus syarikat is under the company's constitution and also articles of association. Tadbir urus adalah melalui perlembagaan syarikat, iaitu management of the company is under the company's constitution and also the company's article of association. Whereas what about the partnership pula? Wait one moment. Madam terlepas pandang the PowerPoint just now. Sekejap ya. Sebab something wrong with this computer. Wait one moment. Just wait here. Okay, what about the tadbir urus of a partnership? The management of a partnership is melalui perjanjian di antara rakan-rakan kongsi. So how we manage the partnership? Management of the partnership is through the agreement ataupun contract between the partners of the partnership. And then remember again, the liability of a partnership is limited. Okay. Liability of a partnership is unlimited. Dia tak ikut saham dia. Dia tak ikut berapa pecahan perkongsian mereka. Tetapi liability of the company shareholders is limited only to the amount of their shares. Okay, company law recording number 5. We are talking about the constitution of the company just now, ya. Constitution tu namanya, the name of the constitution of a company is Memorandum of Association and also articles of the association. We can actually, as board of directors, make pindaan, make amendment to our constitution ataupun memorandum of association and articles of association. But we must get the majority votes, VOTES, ataupun majority undian in the board meeting, BOARD meeting, board meeting. But basically, according to Companies Act 2016, we cannot do any amendment if this is goes in conflict ataupun goes contrary, tak sama dengan Companies Act 2016. We cannot change our memorandum association or articles of association jikalau this is bercanggah dengan undang-undang, against the law. So whatever we do, it must be bona fide. BONAFIDE, two different word. Bona fide, bahasa Latin, maknanya must be in the good interest of the company. Must be in the good interest of the company. And not only that, lastly, whatever amendment we want to do to the company constitution, maknanya a memorandum of association and also articles of association, we cannot do it if it bring injustice to the shareholders and board members. Okay, if we hurt them financially, in any way, or if we hurt them in any way against the law, then that is, that amendment is illegal. We can say it's illegal and void, tidak sah. And lastly, Madam want to speak about the doctrine of separate legal personality again. The case on point is Solomon versus Solomon, SALOMON versus Solomon, SALOMON. You are not a law student, so Madam do not expect you to baca. I don't expect you to read the case unless you are so interested. And but basically the doctrine that comes from the case, apa yang case tu cakap, the case is a leading case ataupun precedent case. It says that the company, at the moment of it being launched as a company, at the moment of it being incorporated as a company, the company has a separate legal personality, ataupun the company has a corporate personality now. It has a corporate veil. A company have a life of its own. It can sue in its own name. It can be sued in its own name. It can hold property. It can live forever and ever, although the board directors pass away, etc., etc., etc. Wa minallahu taufiq wa hidayah. Assalamualaikum warahmatullahi wabarakatuh.